So an expert witness is distinguished by a fact witness by one thing, usually. And does anybody know what an expert witness can generally do that a fact witness can't do, besides Chuck? Does anybody know? Yes?
Render an opinion.
Yes, sir. Yes, sir. How'd you know that?
I read your notes before.
Could you just try to remember not to hand out those notes before? Just try if you could. So that's right. So what, and this is the big deal. This is the big distinction when all is said and done between a fact witness and an expert witness, is that courts will allow experts to render an opinion or opine. Opine. That sounds like opine, you have a little wine and you say opine, you know. So experts can opine. Where's wine, by the way, Chuck? You said we're going to have wine for the afternoon session.
That was yesterday's.
That went out with the fire alarm,
Well,
right? Somebody was.
We came to the determination you don't need any more today.
No, that's coffee. Usually they say that about coffee. So anyway, the experts can offer opinions. So when you are hired, and you should do this, you should become an expert in case it's fun, it's interesting, it's good stuff. When you're hired as an expert, you are going to be asked to give an opinion. And generally speaking, only you could do that. A fact witness can't. So that's the difference. Now, and the reason that we have experts in cases is because there are certain things that are so specialized and require a level of education and experience that regular people don't have. It falls outside of the area of the realm of the ordinary experience of the ordinary person. So, you know, if somebody says, was it hot out today? Most people could say it was hot out because we all live, we all go out, we all work in gardens, we know what hot is, you know. Was it cloudy outside? Regular people could say it was cloudy outside, and you're not gonna, everybody knows what that means. But, what was the percentage of diminution as a result of the contamination of the factory 2 blocks away from the subject property? Regular people aren't going to be trusted to answer that. Fact witnesses aren't going to be trusted to answer that question. That's where the courts and the fact finders benefit from having an expert. When you're there, you're hired by a lawyer who's ultimately, the client's ultimately paying your bill, unless you do it for free, or it's for your brother-in-law. But if you are, you will have that brother-in-law, right? By the way, you get your law license and you never know how much family you have until you get your law license. Okay, I mean, I can't tell you. People are popping out of the woodwork. I never saw them at a Thanksgiving. I never saw them anywhere. All of a sudden, but it's true. But the thing is, what you're gonna do is offer an opinion. Now, you're being retained through a lawyer paid by the client. But, conceptually at least, you're not partisan. You're really not partisan. You're not a Democrat or a Republican. You're there to assist the fact finder. That's why you're there conceptually. That's the idea. You're there to assist the fact finder in an area that people ordinarily just don't know much about. That's exactly what experts do all the time. Every case, no matter what it is you're hired to do, whether it's a pollution diminution case, whether it's a tax appeal, doesn't matter what it is. If you're hired as an expert, every single time, all of the time, without exception, even in Louisiana, you are there to assist the fact finder in a very, very unique, discrete area, and you're going to do that by offering an opinion. Sir, in a tax appeal, ma'am, let me ask you this. Based on what you know, what would be the reasonable value of that property, especially in light of the very, very poor condition it's in, right? Because they were all in poor condition, right? So anyway, that's an opinion. That's not a fact. That's not a fact. And I'll tell you how I know it's an opinion, because the appraiser for the municipality has a very, very different opinion about the exact same issue all the time. So it's an opinion with which reasonable minds could differ. Doesn't mean that somebody is unreasonable, usually, just because they differ. It's an opinion. Now, Mr. Sinkovich,
Yes, sir.
For an opinion, expert opinion to be good, what should it be based on? What's the recipe?
I mean, it should, okay, it's got to be based on, number one, sufficient facts and data. It's also got to be a product, and this is basically outlined in the next rule, Rule 702. It's also got to be
Why don't you go
testimony
there then? Oh,
that's, sorry.
Good.
Yeah, it's good. Good segue. No, it's also testimony that's going to be a product of reliable principles and methods. So maybe less to do with appraisals, but more to do with, we have some cases with very unique scientific analyses, and we use some stuff that's maybe outside the ordinary course of what a normal environmental engineer would use to determine when contamination happens. So the really great expert testimony is based on something that's either generally accepted or at least has a scientific basis.
That's right.
And then the third is
Oh,
that
I didn't, you done. No, go ahead, what else?
the third being that those principles are applied correctly and using sort of a common sense approach to the facts. And that's really sort of the quickest way of explaining how.
What's our thing?
What?
Tell
Tell a jury a story.
a story to a jury.
Yeah.
Tell a jury, so this is what you gotta do. You wanna tell a story to a jury, it's gotta be grounded in reason and grounded on principles that are familiar to your profession and facts that are verifiable. That's what you want to tell a story to the jury, and that's what it is. So the rules in federal court generally require everything that Mike just said. Different rules in different states vary about what is acceptable as an expert. Some are more lenient than others, and actually we'll talk a little bit about some of those things later. But I don't really care what the rules say. You care as a lawyer in litigating a case because if the rules require certain things and your expert doesn't meet those standards, the expert's going to get thrown out and we'll never be able to talk to the jury. So I care then because my client's going to be unhappy with me. But for the purpose of our discussion today, I don't care what the rules say. The fact of the matter is this. If you want to be a good expert, what you say has to be grounded in facts. There have to be facts that support what you're saying. And there should be acceptable principles that you're using as guidelines and that you're applying those facts to. And so you have your USPAP standards, and you have other standards that are acceptable in your profession. You want to stay within familiar ground. You want to use those kinds. There's also Freddie Mac guidelines that we could talk about a little later, and we're going to, and other governmental guidelines that concern appraisals of contaminated property in their particular areas. Those are the kinds of things that you want to be using and citing freely and as often as possible in your report, and you want to have facts that you can document and verify. That's your recipe, and then you have a delicious chicken soup. And somebody like me cares a lot about chicken soup. So, but that's what it is. What happens if what you do is acceptable, meets the minimal requirements, but according to the rules of evidence in that jurisdiction, but it doesn't have a lot of that. Let's say you've got some pretty good comps, but you're relying on some principles, some appraisal principles that are fairly novel and not necessarily promulgated any place or routinely relied upon, something like that. What do you think happens? Anybody know? You get torn apart. It sounds like, and that's what's going to probably happen. You're going to be subject to cross-examination, and you're going to be, not happy when you go home and see your spouse that day. How was your day today? Oh, don't ask. So, and you're going to lose probably, So, and that's why I tell you, I don't care what the rules say in terms of minimum requirements for your expert report. If you really want to do a good job, now, you can't always do this. Sometimes you have these unique situations, and then you just do the best you can. But the more your report is grounded on traditional accepted principles, the more you are using verifiable comps or whatever other data you're using as factual predicate for your opinion, the more that is, the more you can double and triple check your opinion. The better off you're going to be, the better likelihood you're going to have of success. Because probably if you're that strong, the other side isn't that strong if their opinion's very different than yours. Yes?